Alan Bakke never wanted to be famous. He just wanted to be a doctor. Little did he know that his two failed attempts to gain admission to medical school would lead to a landmark decision by the United States Supreme Court. By the time it was over, his case would forever cement his story into the national dialogue about affirmative action. At the time of Bakke's application, the University of California Davis Medical School had two separate admissions programs: a general program that handled most applicants, and a special program for minority and economically disadvantaged students. White students could theoretically request consideration under the special program if they were economically disadvantaged, but no white student had ever been admitted through the special program. In each year's incoming class of 100 students, 84 seats were open for applicants in the general admissions pool, while the remaining 16 were reserved for minority students through the special admissions program. Although Bakke's qualifications were impressive, his scores fell shy of securing one of the 84 seats available through the general admissions process. And as a white male of average economic means, Bakke wasn't eligible for the special admissions program. He was denied admission 2 years in a row. In both years, candidates were accepted through the special admissions program with test scores substantially lower than Bakke's. Bakke filed suit in California trial court, arguing the special admissions process violated the Equal Protection Clause of the 14th Amendment. Bakke also cited Title VI of the Civil Rights Act of 1964, which prohibits racial discrimination by recipients of federal funding. The trial court agreed with Bakke, and the Supreme Court of California affirmed. The United States Supreme Court granted cert to determine whether public institutions of higher education may use race in making admissions decisions consistent with the Equal Protection Clause. The court held that although universities can use race to evaluate candidates under some circumstances, they can't establish a racial quota system. Justice Powell announced the judgment of a deeply fractured court. There was no majority opinion, but 4 justices agreed with Powell that the university's special admissions program had discriminated against Bakke. Powell explained that racial classifications are inherently suspect and require application of strict scrutiny. To survive strict scrutiny, the racial classification must further a compelling state interest, and its use must be the least restrictive means available to achieve that interest. The university contended that its special admissions program served compelling interests in remedying past discrimination, facilitating health services in underserved areas, and increasing academic diversity. First, Powell determined that remedying past discrimination by society at large wasn't a compelling interest because the university itself hadn't engaged in any discrimination. Next, Powell acknowledged that promoting health services in underprivileged areas might be a compelling interest, but the university failed to establish that the special admissions program was actually geared toward accomplishing that purpose. Finally, Powell agreed that increasing academic diversity presented a compelling interest. However, he determined that the special admissions program wasn't the least restrictive means to further that interest. Powell reasoned that there's more to diversity than skin color, and rejected the university's use of a racial quota system as, quote, discrimination for its own sake, unquote. The court thus held the university's admissions program to be unconstitutional and affirmed the California Supreme Court's judgment. Justice Brennan, concurring in part and dissenting in part, would have upheld the special admissions program. In his view, programs that use racial classifications to remedy past discrimination serve a compelling state interest and are thus constitutional. Justice Marshall also wrote separately to emphasize his view that the Equal Protection Clause permits the use of racial classifications to remedy past discrimination. Justice Blackmun's opinion expressed his belief that the judiciary was ill-equipped to judge the wisdom of admissions programs. He also noted that race must be taken into account in order to combat racism. Finally, Justice Stevens concurred in part and dissented in part. He wrote that the special admissions program violated the plain language of Title VI of the Civil Rights Act of 1964 by excluding Bakke from an institution that received federal funds. Because this statutory violation was sufficient to affirm the judgment below, Stevens wouldn't have reached the constitutional question. Bakke was a monumental case on affirmative action that invalidated the use of racial quota systems. Due to the fractured nature of the court's ruling, Many relevant questions remained unsettled for decades until they were answered in another landmark decision nearly a quarter century later in Grutter versus Bollinger.